All right, okie dokie. Well, firstly, thank you everyone for joining. I am Lucy Young. I'm the president of Warwick Law Society. This is just going to be an event about public policy, specifically relating to the Police Crime Sentencing and Courts Bill that's currently going through the House of Lords, having already succeeded through the Commons. So without further ado, I guess I should get going, if it works. Okay. So the Police Crime Sentencing and Courts Bill has sparked nationwide protests under the guise of Kill the Bill and other activist causes. Priti Patel initially began drafting the bill after extensive pandemic protests, especially ones relating to Extinction Rebellion and Black Lives Matter. She's actually been on Politics Live talking about her, kind of unease relating to the public protests that were taking place. So the bill itself announces a police covenant which would provide harsher sentencing for those who harm or assault an officer, and the barriers of said harm/assault will be defined by the Home Secretary according to provisions under this bill. So specifically relating to this event and in the context of public assembly, Priti Patel has so far defined serious annoyance as a form of serious harm, with forms of public obstruction potentially resulting in a prison sentence. As stated as well, some terms within the bill are pretty ambiguous, and this just leaves room for further interpretation later down the line. So as well, this comes at a pretty volatile period of time, especially the provisions that relate to extension of police powers, especially with the findings from the Sarah Everard trial. So just as well, for a brief overview, this part down here is where the bill sits at the moment. It's currently in the committee stage, having been through scrutiny within the Commons. I will explore some statements made by MPs within the second reading just in a little while. So yeah, this is where it's at right now. I think the last hearing that it had was on the 1st of October, and that's when they talked about provisions about extending rights in regards to technology. Sorry. But yeah, so the bill was first introduced in March, and it was rushed through to the House of Lords in July, and it's still being heard there now. There are various provisions within the bill that some might deem to be problematic and controversial, and these are listed just down here to the bottom left. So the ones that we'll be exploring today include imposing conditions on public assemblies, which is contained within section 56 onwards, I think it's about section 58 or even to section 60. I'm not too sure about that one. And then there's also the extension of powers, and that will amend the Public Order Act 1986. Some other parts that won't be covered as much here, but are still really important, increased sentencing for assaults against frontline workers. So that's potting, is a new term that they've essentially created for an amendment that is still being discussed. And we can relate that with Belly, who was spat on her way to work. She developed COVID symptoms, she was hospitalised, and she eventually died. The CPS held that there wasn't enough evidence to support a public claim, but they also won't release the name and the details of the perpetrator. So it means that there is no justice for her and her family. So that, just to kind of provide a little bit of context, that could be why potting is a little bit contradictory in the case of Belly here. And at least if they did introduce potting, they would have to address her death in relation to the COVID-19 pandemic. Another part is part 4, section 62 to 64, relating to unauthorized encampments. This closely relates to the Gypsy Roma community, and there have been extensive research projects done by Gypsy Roma charities across the UK about how this is essentially a new form of institutionalized racism, in the sense that while encampments, if they are unauthorized, are technically illegal, local councils and the government at large won't provide spaces for encampments to actually exist. So essentially the Gypsy Roma community are travelling up and down the country with very little space to use. So they essentially have no other option but to kind of pitch up somewhere that is unauthorised. So if the council were supportive of, their culture, there simply wouldn't be a problem to begin with. And then the final part, which is closely associated with the Black Lives Matter protests that occurred throughout the pandemic, relates to Section 46 and criminal damage to memorials, which basically just changes and actually increases sentencing if you are to, harm or damage or ruin a memorial piece or statue. Okay, so these are parts of the bill that some may deem problematic, and it's actually the main part of our session today. So Section 56 imposes conditions on public assemblies, and as you can see, there's a lot of kind of terms thrown around about serious disruption, discussion of kind of noise being a form of serious disruption, and defining serious harm and serious disruption to the life of the community. Now, as you can see here under subsection 6, the Secretary of State may, by regulations, make provision about the meaning for the purposes of this section, and that kind of touches upon what I was drawing about before, about Priti Patel being able to define the confinements of the legislation itself and how it's applied in practical terms. These are some comments from MPs during the second reading about the PCSC bill, how detrimental it could be upon practical application. And this is actually as well cross-bench. So we've got a Conservative here who's actually disagreeing with the bill as well. And then this is a potential amendment that was proposed that was never followed through with. As you can see, the clear star here indicates that it was never adopted. And if it was adopted, it would probably be contradictory to the bill at large. And then these are also, it's scrutiny from the joint, basically the joint kind of scrutiny bench of the Human Rights Committee. So that's just kind of what they've said there. All of these slides will be provided after the fact as well, if you did want to go back and look through. There are links attached too. And then this is just further comment, basically suggesting that the Joint Board doesn't really agree with the bill as well, and it's super problematic on multiple grounds. Okay, so the House of Lords have also been assessing the applicability of the bill, but mostly in respect of police presence and powers. As I mentioned before, just a few days ago, there were discussions to extend powers to enable retention by the police of personal data relating to non-criminal conduct perceived to be motivated by hostility. So this can be a super invasive tool. It's been seen to be used in some states in America, and it's really invasive for just regular people who want to live their everyday life. So further amendments proposed in front of the House include potting, which is what I mentioned before, relating to Belly and her murder, essentially. Recording the sex and acquired gender of alleged victims and perpetrators of crime, and then also the laws around the desecration of a corpse and concealment of a body, which relates to the Metropolitan Police and certain officers, just being totally inappropriate around Sarah Everard's death. So yeah, from what can be seen, not much attention has really been paid by the Lords to elements of the bill that would restrict the right to assembly and right to protest. And that's essentially this discussion today. So I have gone on for a little bit, but just to introduce our current speakers, we do have Oliver from Amnesty, and we have Sahil from the Good Law Project. I'll just disconnect and stop presenting my screen so we can have the session here. Hello, Oliver, would you be able to introduce yourself, your role, and just life at Amnesty, I suppose?
Yeah. Oh, I've got an echo. I hope that's not me. It's stopped now. Good. Phew. Hi, I'm Ollie Feely-Sprague, and I'm the Programme Director for our work here at Amnesty UK on a wide range of related issues. So my official title is Programme Director, Military Security and Policing. and I've been in post since 2006. But I've got like 25 years experience with civil society groups looking at issues to do with human rights and their relationship between weaponry, equipment, use of force, policing powers, those sorts of areas. So at Amnesty, I kind of divide my time into two distinct chunks. So the work I do on kind of law enforcement and policing, and the work I do on the arms trade and controls over sensitive technologies around the world. If that kind of makes sense, it's an incredibly broad range of issues. So I don't cover every single aspect, but I try to focus on certain specific things. And for the purposes of this session, I'm the person in the section at Amnesty that's responsible for our kind of policy inputs into the police crime and sentencing bill. So do you want me to give a quick overview now of where we're at with the bill and stuff?
Yes, please. Yeah, it would be super useful.
Okay, cool. I'll try to keep it brief and headline. I don't, because you've already got the slides with all of the clauses and the details, so you don't need me to repeat that. But I think the one thing I would say, and you touched upon it in your introductory remarks, is that this is an enormously broad bill, and I think that's one of the big problems with it. So it covers everything from curtailing the rights to protest through to the powers to curb dangerous dogs. You name it, you'll find something in this bill. And I think it's the breadth and the complexity of it that adds to the considerable challenges that we have when we're trying to defeat it or amend the bits and engage on the substantive issues to the necessary details, given the time constraints of the parliamentary process. I mean, it's interesting. You've mentioned the work in the Lords, and I'd say at this stage, the Lords is our best hope to change this, right? So traditionally, the Lords have been the place where the parliamentary arithmetic works a little bit in our favour, but also as a more reflective, it's slightly odd given the way we think it, but the Lords are actually more progressive than the Commons are on these issues and take a much more considered view on undermining long-established rights and a very much more cautious approach. So our best chance of amending this is going to be in the Lords, but the trick will be when it goes back to the Commons, whether the Commons will accept or just overturn them. So in this thing called ping pong. So what's interesting is that I talked a little bit about the complexity of the bill. The amendments paper is currently running slightly longer than the bill itself. There's hundreds of amendments, and I don't know whether this is a ploy by the Lords because they're exceptionally grumpy about being presented this behemoth bill to kind of wrestle with. But the committee stage, which is where they go into nitty gritty on the amendments, is currently running about 10 days behind where it should be. So the timeline's a little bit difficult to predict where we are on the process, and they have to keep going. I don't think the government can stop it. So it's taken a very, very long time, and the sittings are going on incredibly late. So they're running twice a week, and they're not finishing till 10:30, sometimes 11 o'clock at night. So they're really long sessions. And I think what's interesting is that they've played a little bit with the timetable, so they're not taking the bill in order. Well, they are taking it in order, apart from Part 3, the section that deals with public order and protest. They're tagging that on to the end, so they're doing parts 1 to leaving out Part 3 and returning to Part 3 at the end. That's very interesting because the reason why they're doing that is because they've decided, because of the effects of the Insulate Britain protests, that the powers in Section 3 don't go far enough. So the government are going to bring their own set of even more restrictive amendments to the bill, specifically to curtail the threat as they perceive it to the Insulate Britain. Now we don't know exactly what they will bring in, but I think we can hazard a guess, and I think you don't need to look much further than the thing that Priti Patel misquotes all the time, which is the Her Majesty's Inspectorate report on getting the balance right. And in that, it had a series of proposals that were rejected as being too far, too extreme. And one of those was basically a new banning order. So an order that can be introduced to outright ban any particular movement and protest, with increased sentencing and fines allocated, and also obviously the corresponding ministerial regulatory power that would allow ministers as well as the police to introduce these things. Now, in the Getting the Balance Right report from the Her Majesty's Inspectorate and the Home Office's response to that, it was originally decided that an outright prohibition order was too extreme and that was too far down the curtailing of fundamental rights to protest. But I think that's what's coming back. I can't say it for sure, but my guess is that that's what's coming back, but we won't know that for several weeks yet. Right, that was a bit of a digression. I would say that for Amnesty, we're focusing on, out of this enormous bill, you could focus on so many things, but we're focusing on 4 main distinct areas. So obviously the thing I've just talked about right now, which is the protest and public order powers that are in part 3. We're also part of a wide-ranging coalition working on the part 4, which is the authorised encampments and trespass sections. And I think that section has just started in the Lords Committee stages today. And there's a series of amendments trying to soften those powers. But also, I think for us, what's really important, and we've just had this has already been through committee, so this bit's gone. But this is the section 2 on the serious violence duty, which is essentially going to lower the data protection thresholds and require a lot of local service providers to provide lots of information to the police around individuals that are suspected to be involved in serious violence. And we have enormous concerns about our existing work on racial profiling tools within police systems, that serious violence duty is essentially going to cause increased racial disproportionality in the system. And aligned to that in section 2 is part 10, which is introducing these things called serious violence reduction orders, which one of the consequences of will be that they'll vastly extend the powers of stop and search, which are already highly racialized tools, and they'll remove the grounds for reasonable suspicion. So anyone suspected of having a serious violence reduction order on them can be stopped and searched at any time without reason, basically. So those are the kind of, I'm not really going to talk much about part 2, part 10. I'm very happy to talk to you at length about them if you've got any questions on them, but I don't think that's the main focus of the discussions today. Right, I'll give a very quick. I'm not an international lawyer, and we have a lawyer here, so if I get it wrong, he'll probably correct me. But my Amnesty's basic view, and we think the bill as written is out of step with the UK's international commitments under international human rights law. And it's not just us that have said that. The various UN bodies have said that. The Special Rapporteur on Freedom of Expression has said it, for example. So as you'll know, that the freedom of expression and assembly, they're covered under Articles 10 and 11 of the ECHR and our Human Rights Act, but also wider than that, there are Articles 21 and 22 of the International Covenant on Civil and Political Rights. And the key here is that those things all give a positive duty on the state, and by the extension of that, the police, to protect and uphold the right of peaceful protest. So it's a right you have that they have to protect. And I think, interestingly here, I think go back to 2020, there was a commentary from the Human Rights Council that's quite important, because the commentaries are quite often a way of articulating in practice what the phrases in the international treaties might mean. And the commentary from the Human Rights Council said that governments generally about the right to protest should uphold the rights in a way that avoids overly broad definitions to place restrictions on those rights. And it goes further to say that protests are by very definition likely to be inconvenient and disruptive. And the burden on government is essentially that they're required to give a wide degree of tolerance to that disruption. So take that commentary and the standards as they're written, and then look at the clauses of the bill, adding subjective terminology like serious noise, annoyance, unease, and you'll see that there's a very clear disconnect between what the UK is supposed to do and what it's actually doing. And I think the other thing I would add here is that the governments are not supposed to introduce any punitive measures that are likely to have a chilling effect on anyone who wishes to exercise their rights. So in this case, their rights to freedom of protest. So by increasing the fines and penalties that can be put on organisers for breaching the conditions, by increasing the likelihood, I mean, that they're lowering the threshold by which you can be prosecuted as an attender of a protest to something that you ought to have been aware of any restrictions that may have been placed on the protest. And when you're dealing with things that are lawful in any other context, so you're not asking about people bringing weapons. You're saying, for noise, you're asking people carrying musical instruments. You're asking people walking down the street to stand in a park or something. You're things that are. You're putting conditions on things that in any other context would be perfectly lawful. And we think that that's the very definition of a chilling effect, because people, in order to prove they're innocent, will have to be arrested and convicted and put before a court system to prove that what they were doing was okay. Whereas it should be the other way around. It should be a positive right to do it in the first place, if that makes sense. So, and I'm going to finish by just running through a couple of our main key points, or I would say myth busting about the bill and what's said. And if you engage with the Conservative Party and you write letters to them or you meet ministers, they will trot out these justifications about why they're doing things, and they are mostly bogus. If you just scratch a little bit beneath the surface and unpick it a bit, you'll find that what they're saying to you doesn't quite add up. So the first myth to bust is that the government claimed the police are powerless. Well, that's completely and utter tosh, because I've been working on this area now. I've been working on it for 27 years, and I've never seen one bit of policing legislation that's given the police less powers. So in 26 years, they've had more and more and more and more powers, and they already have an enormous range of powers and laws that they can use, including the use of reasonable and proportionate force. So, it's already an offence to block a public highway, to cause harassment, intimidation, to be violent, to cause criminal damage, to be involved in aggravated trespass. The police already have the power for preemptive arrest, intelligence-led arrests, surveillance and monitoring. All of those things happen all the time, and they've been happening as long as I've been involved in monitoring protests, right? Protesters have been arrested and convicted for any number of offences since I've been working on this for 25 years. And my contention here is that public order and the policing of protests is as much to do with tactical considerations that police officers may take on the day as it is to do with the legal powers that they might have. And you can give, there's a key example here. So you've got Bristol, I think, is a really good example of what I mean here. So in the early days of the Black Lives Matter protests, when, after about 20, I used to work in Bristol, and I used to work just down from the Colston Hall. This was back in the mid 1990s, and it was an issue then that a famous concert venue was named after a slave trader. So it's no surprise that that's been simmering in Bristol for years and years and years. So when they tipped the Colston statue into the docks, basically there was no major breakdown in public order. It was just a statue of an old racist was 20 years too late, was got rid of, right? The police took a very kind of laid back approach and kind of facilitated that to happen, and there was no real major trouble that took place, apart from members of the Conservative Party and the Home Secretary that went apoplectic with rage that such a thing could happen, and a very heavy political leaning on the Bristol police to take a much stronger line on these types of protests. So contrast that a few months later. There was another set of protests in Bristol, and this saw a much more confrontational and aggressive police presence. There was a lot of riot gears. The riot vans were there. The police, you'll notice as time goes on, police have got more and more paramilitary with the way they dressed to deal with public order. So they had their riot shields and they had their helmets and the masks and everything like that. It was a very intimidating thing. And what you saw there was a much more violent protest. There were skirmishes, there were fights, there were heavy-handed police tactics, there were demonstrators kicking back. It was a much more unruly mess And that, to my mind, is about two different tactical considerations about how to manage the protest. One, no trouble. The other one, what's a lot of trouble. And that leads me on to the second thing they'll talk about. So the classic misdirection. You see a lot of this in the tabloids, which has obviously been fed by the government. This is this peaceful versus violent issue. So violent protesting and acts of violence in protests are already illegal, right? The police have enormous powers to deal with that. They can, they can even deploy lethal force against you if you are so violent that they think you are an imminent threat to the lives of others. So the violence, though, is the term that I think is widely misused, because a protest isn't violent by virtue of sections of those protesters or individuals behaving violently. And that doesn't prevent everybody else's right to peacefully protest at the same time. So I think it's all too easy to label an entire protest as being violent because there have been incidents of violence at them. And I think I'll finish here because I think it's probably time to hear from others and to get into the questions, even though I've got a lot more to say. I think the third myth that I think is very important here is this thing about balance. You hear this all the time about how the balance has tipped the wrong way towards protest, and that ordinary members of the public are just fed up and sick to the back teeth of all this stuff. Now, again, in our view, the balance is already there, right? So there were literally hundreds of court rulings in the UK and across Europe on both sides of this argument. And the system already balances the rights of others versus the rights of protest. So, for example, there's a very famous French court case, I think it was an ECHR case, where, and it's relevant because it was about lorry drivers. So it was a bunch of French lorry drivers who did a go slow on some major roads in France, but then they went a step further and decided to block the road. And the court essentially ruled that the going slow was I'm paraphrasing here, but the courts basically ruled that the go slow was legitimate to the aims that they were trying to do. The inconvenience was legitimate, but the blocking wasn't. It was a step too far. So the balance and proportional decision was already balanced here. Likewise, in the UK, you've seen anti-arms fair protesters, right? So there's a famous Supreme Court course from a few months ago where the protesters won their case, and what they did was they blocked a road that was an access road to the Desai Arms Fair, and they prevented the access of the equipment and the military vehicles and so forth getting to the fair, and it was ruled in that case that the disruption was proportionate to the aims of the protesters. On the other side, you have the environmental campaigners that blocked access to the newspaper printing presses, and they were convicted of being activity that was not proportional to the aims that they were in. And I've actually personally had a personal experience on the arms trade side of things of this working in both contexts. And I'll finish here with an anecdote, in that I often get called in to be a special witness in kind of anti-arms fair protests. So I've done two for Dicey, and one of them related. Well, they both sort of related to criminal damage. One of them, the individual was found guilty. The judge accepted that he had a legitimate reason for what he was doing, that he had a genuine he had a genuine belief that he was trying to prevent a greater crime, but that the damage he did was not proportional to stopping the fair. So this guy was basically graffitiing a load of posters and defacing them, and the judge ruled that he hadn't done enough disruption to stop the activity that he was protesting about, so he lost the case. In the other one, it was people that were chaining themselves to the bottom of like lorries and things to prevent access again. And in that case, the judge did rule. He said, you think that you have a reasonable expectation to believe that at this arms fair, there are things that are going on that are potentially crimes, especially in the international legal situation. Israel, Gaza, Palestine, Yemen, those sorts of issues. And therefore, it is entirely legitimate for you to have a reasoned belief that stopping these vehicles from exiting will help prevent the sale of these things in the future. And that the judge accepted that one. So that's two examples of the balance. And I will stop there because I've already whittled on long enough.
Thank you so much, Oliver. It was super interesting, actually. And you're so right. Like, there are so many different facets to this bill that honestly, you could yap on about it forever and you still probably wouldn't get to the end of your argument. So I completely get you on that. Sahil, up to you. Sahil works with the Good Law Project. In our Instagram post, we gave a pretty brief coverage of their involvement with the case against the Conservatives. It was Michael Gove and Matt Hancock and their crony contracts.
Among many others. Sorry.
But yeah, so take it away. Just
Sure.
explain your work. And
Sure. So thank you firstly for having me. And so just by way of introduction, I'm a solicitor at the Good Law Project, as you said, and I work across our what we loosely call our good governance work stream and our environmental work stream. And sort of my work largely focuses on developing strategic litigation. I'm a public law solicitor by training, so I also act as a solicitor on those cases, but also do the sort of case development side of things. And part of our role also obviously includes liaising with the media, parliamentarians, etc. And firstly, I echo a lot of what's been said by Oliver. He said it far more articulately than I will. So to take his word as mine as well on this issue, I mean, internally we've started calling this bill a little bit of the sort of the dog whistle bill, because it covers statues and baying mobs and protesters and travellers and all the sort of bogeymen that the government has created over the years, instead of actually sort of tackling far more important institutional issues. And sort of obviously, so I'll come on to my general work, and of course later if there are any questions about Good Law Project's work more generally, I'm very happy to take them. But from an organisational perspective and from my own perspective, obviously the bill concerns us because of how sweeping it is in its scope and wording. But before I sort of go into that, and actually that's already been covered by Oliver and your introductory remarks, there were sort of three broader themes that I thought were worth thinking about, and as Oliver was saying, I'm sort of jotting them down. And the first one is the shift in perspective, one from how protest has always been viewed as a sort of fundamental right, to the debate shifting to it becoming some sort of gift of the state. And I think that's quite an important perspective to bear in mind, because that's not how protest is as a principle of law. It's not also how protest is traditionally viewed in this country. But that shift in debate has a real impact on the way the debate's been conducted in the media. The tabloids are very obviously happy to talk about protest as some sort of thing that the state extends to you, whereas it's obviously a fundamental right that we all have. It obviously leads to a shift in the way the police approach the issue. And as Oliver said, the police have always been hankering for more and more powers. They've never thought their powers are enough, even though they are. And of course, it can have and all of this, the debate can have the practical bits of the provisions, but the debate itself can have a chilling effect on protests, right? And all of that, and that is a point of fundamental concern. I think the second sort of worrying theme for me is how ineffective what we've traditionally viewed as the parliamentary safeguards are in contexts like this, and are increasingly becoming. I mean, we only need to look at what's happening in Parliament today around sort of lobbying issues to show how weak parliamentary safeguards actually are at the minute. Obviously, the government has a massive majority, which makes things easier on some fronts, but despite that, a bill of 300 plus pages going through Parliament with little or no scrutiny should cause us a lot of concern. Similarly, if you think, a stinging report by the Joint Committee on Human Rights will have some sort of impact, the Commons don't think it doesn't sort of really factor that in. And then as Oliver said, often it's the Lords, the ones who we think of as sort of traditionalists and sort of stuck in their conservative ways, who are actually the most progressive voices on these issues, because I don't know, they see issues slightly differently from a slightly different perspective. And finally, I find it quite concerning how increasingly policy development, it doesn't really take different voices into account, and this again is a theme of wider interest to us in Good Law Projects. Whether we're talking parliamentary standards, public appointments, issues of major policing policy, the question of whether racism exists in this country, answer yes. But the government's increasingly interested in cherry picking individuals, commissioning reports from people who will give them exactly the answer they want. And as I said, that's obviously an issue of wider interest to us at the Good Law Project. And obviously looking at the Act itself with my sort of lawyer hat on rather than my Good Law Project campaigner hat on. Obviously, we've talked about the clauses themselves that are problematic. And it's when you look at the Act as a whole, it's very difficult to escape the conclusion that the Act it's very much, the bill is very much an attack on the nature of protest itself, right? There's a long line of domestic cases, European cases that I mean, I love this line that the right to protest is an unruly thing. Protest is designed to make noise, to cause disruption, fuel debate. And if you take away that very essence of debate, you sort of neuter the right. There's no point in saying that the right exists when you've neutered the very sort of core of it, the very essence of it. And you know, you may or may not agree with what a certain group of protesters stands for, but no sort of path-breaking change has ever happened through sort of knocking on doors and writing letters, has it? And obviously, just taking a further step back, you talked about the issues around the broad nature of the provisions itself. When I'm reading those provisions as a lawyer, it's really annoying me because, one, as soon as you see the breadth of those provisions, you know the police, sometimes for sort of the wrong reasons, but sometimes purely the practicality of how the policing of protest takes place, they will always test the limits of their own powers. And if the wording of a provision gives them the scope to play around with it, they will test it. Why wouldn't they? Right? That's exactly what they want to do. And in the sort of white heat of the policing of a protest, they will go further. And this is always the government's response, right? The government's response on a lot of things is some of you may have spotted this, but they issued almost a sort of myths going around, just like Oliver's busted some myths. They tried to sort of put out this one pager on gov.uk somewhere about what is this bill meant to do and what are people saying it will do. It's actually not going to do all of that. That's really not the point of it. As soon as you leave that scope for ambiguity, that will be exploited. And again, the logical consequence of all of this is that people could be dissuaded from marching or demonstrating. People could go to protests without actually knowing what conditions are and without knowing they're going to be falling foul of whatever conditions are imposed. And to be honest, it's of little practical value, thinking of it from a sort of litigator's perspective. It's of little practical value to protesters to say that the conditions can later be challenged in court. There is no point to it once the protest itself has been stamped on and nipped in the bud. So all of this is sort of a very overarching way of saying it's incredibly concerning. And the provisions around Gypsy, Roma, and traveller communities, of course, you know, fundamentally criminalising a way of life, also of massive concern. And from our perspective, what we've been trying to do is sort of support a few MPs. Obviously, our best case scenario, particularly focusing on Hertfordshire and the protest provisions, is for that whole pot to come out. Being honest, the parliamentary math suggests that's not going to happen. So we are trying to work as far as we can with MPs to try and see what we can do to think around the edges. Ultimately, it's going to come down to a bit of that parliamentary ping pong. And you've got to hope that at some stage, you know, parliamentarians stand up for what they believe in. And just on that sort of theme, we talked about how initially the Home Secretary having the power to make regulations, and that's a wider problem, right? And that's, you know, the protest bill is one example of lawmaking through what I think is lawmaking through the back door, which is lawmaking through making fundamental policy decisions, which really should be acts of Parliament that get debated on in Parliament. But this government's track record of the last 5 years is to try and slip through fundamental policy changes through statutory instruments. Things that the trend is quite worrying, because not only are some of them, so there are two ways of obviously introducing statutory amendments, and one of them involves basically no debate in Parliament. And there's an increasing trend for government to do that. So as a Good Law Project, we actually identified an issue around state aid regulations, a very unsexy context in which to try and challenge it, but we thought it was a point of principle, and the government backed down eventually and introduced primary legislation on that issue. But there is a slow creep of government trying to find the back door make fundamental policy changes, and that sort of, this is another context in which that's taking place. But apart from that, yeah, echo a lot of what Oliver said. And I think when restrictions and when, you know, yes, in theory, your Article 10 and Article 11 rights are subject to reasonable restrictions, but when restrictions become the end in itself, and when restrictions are not sufficiently precise and unambiguous, so as to actually meet the requirements of Article 10 and 11, I think we're in very, very dangerous territory. And I think civil society has a big role, and obviously, you know, Amnesty, Liberty, lots of organisations are really leading the charge on that. And, you know, we act as a sort of, we think of ourselves in some contexts as trying to provide a second line of defence to see whether strategic bits of litigation can help ever. And we'll continue to monitor that along with other organisations.
Brilliant, thank you. Thank you both for, you know, obviously your professional takes on this, especially in the context of your organisations. So I guess now is the time to open up to the floor. If there are any questions, either to Oliver or Sahil, just pop your hand up. If not, I've got one of my own, but if anyone else wanted to go first, now would be the time. Oh, this always happens. Anyone at all? Okay, well, I have a question. So how much, obviously we know that party politics does play a big kind of influential factor in all of this, but how detrimental do you think it will be to the passing, I mean, obviously it's in the Lords now, but just like the implementation even of the bill if it were to pass through in the state that it's currently in? Do you think the Conservatives will like try to prove almost a point to the Labour Party, especially after the back and forth in like the second reading of the bill itself? That's open to either of you. Yeah.
Sorry, I mean, if I understand the question, are you saying will they sort of go all out to clamp down on protest if once it gets through? That sorry, is that where you're going?
So almost in the sense that, as we've seen so far, they'll always, well, both parties, both sides will try to gain political points. So if this bill were to succeed, how detrimental, I mean, succeed in the current state that it's in, how detrimental do you think it could be to general society, and how far do you think the Conservatives would go to push a certain narrative?
I mean, I think it will tear, and it's a bit hyperbolic, but I think it will really hit hard at the fabric of society and the way we think about we think about protest. I think you know, the police have always had the power, but this is a bit of a legitimization in Parliament and in politics of sort of the long-running police team of we need more because we are ill-equipped. Protesters have the upper hand on these issues. That has never been the case. The police have always had the powers to deal with issues in an appropriate manner as needed. In fact, I feel they've always had more powers than they need. And I think the passage of this bill in its current form legitimizes a lot of what the agenda that the tabloids and the Conservative Party have been pushing for ages, that protest is somehow a bad thing. And you know, that obviously that a lot of that obviously revolves around the specific protests in question, right? I doubt this big push for policing powers would have existed if instead of Extinction Rebellion and Black Lives Matter, you had certain other protests on our streets. I think it fits into a wider, not to make it about party politics, but wider conservative playbook of demonizing Black Lives Matter and Extinction Rebellion. So I think it could be harmful.
I mean, I'll just come in quickly. I mean, I think the bill is part of a much wider and very conscious decision to strip away rights. So we see this bill in context with all the other things, the borders and nationality bills, the CHIS legislation, the rollback on torture from last year. All of that stuff is part of this. You know, they talk about they talk about repealing the Human Rights Act, but they, you know, by the time we get to repealing the Human Rights Act, they won't need to, because they'll have changed all of the other things that work behind the scenes. So it's we have this narrative that it's sort of death by a thousand cuts, and the policing bill is part of that. Is part of that agenda. I mean, I think we have to be very realistic that despite the optimism of activism and the enormous amount of work and passion that we bring to this, it's going to be awfully hard to derail this particular monster. So the best thing we're going to get out of it, I think, will be a slight softening, and even that might be difficult. So then I think that's when we come to Sahil as the second line of defence. So I think that the way we might end up defeating the bill is by rendering the clauses inoperable, and the way we have to do that is through the courts. So basically let's say in theory in 3 or 4 years' time, there's a whole load of prosecutions around what was too noisy. And the judges will basically go, do you know what? This is completely ridiculous. We cannot legislate on this. And all of the cases get thrown out, or the ruling sets a precedent that undermines the whole purpose of the bill in the first place. So it kind of makes it legislatively illiterate, if that makes sense. So I think that's our second line of defence. And obviously we're in it for the long term, so that you have to hope at some point that the Labour Party will be a government, or some other form of opposition will be a government that's not this government, and that we start the seeds now, saying, well, we'll repeal this stuff when we get in. I mean, there's a slight caveat there, because I've noticed a very, very specific, subtle shift on the Labour Party's positioning on this stuff. So when the police crime bill, when it first came out, Labour were caught off guard, and for the first couple of weeks they were very, very quiet. Then I think their activist base got very annoyed and said, why aren't you saying something? And then they came out and they were very strong on the protest stuff. Policing has always been a political issue, right? It's always been a tough on crime, tough on the causes of crime. And we'll have to see what happens, but I notice a slight softening of Labour's kind of, we don't like this, because they don't want to appear to be anti-police. And they don't want to be. I know David Lammy was quite good on the motorway protests the other week, making all of the points that we've just made about there's plenty of law already to stop these people, but the reality is causing serious and widespread disruption and the prospect of being arrested and stuff is the driver for those types of activities. So the more you clamp down on it, the more you incentivize it. So you're not going to be able to stop those extreme levels of protest by putting more powers on. You have to use the powers you've got, because you'll just incentivize what they're doing, rightly or wrongly. However, whatever you view of the tactics there. I think, does that answer your question?
That's perfect.
I want it to be. I don't want to be like. I don't want to make you all think that the world's terrible and we're all gonna. We're all. Everything's going to burn, because hopefully it won't. But
can only hope so. Before we head off, any further questions from the audience? Oh, Tareen? Go ahead.
Yeah, hi. I'll just turn my camera on. Hi. Thank you both, Oliver and Sal, for talking to us today. I was wondering whether you would be able to share your opinion on how stop and search will impact particularly ethnic minority communities, and kind of just elaborate on your thoughts on that, because obviously that's quite a hot topic both in politics and kind of when the law is used as a vehicle for such potential injustice. I was wondering whether you had opinions on that.
I mean, I guess that's probably one for me more, because we do more work on this. I mean, the evidence is overwhelming that tools like stop and search disproportionately impact particularly the black community, but in other contexts, especially with the kind of the immigration side of things too, and the horrible T word, other ethnic groups. But it's primarily a tool that's used against the black community. You're 7, 8, 9 times more likely to be stopped and searched, sometimes more than that, if you're a member of that black community. And there's all of the professional bodies that have looked at stop and search have said that there is a lack of evidence that it actually works. but there's plenty of evidence to suggest it undermines community trust in policing and fuels the cycle worse, because what you end up doing is alienating a whole community of people against the police, who then basically put two fingers up to it, and it encourages even worse behaviour in the first. The whole thing is incredibly counterproductive, and there's no evidence whatsoever that stop and search actually prevents crime. There was the College of Policing, so this isn't Amnesty. This is like the College of Policing did a 3-year research project looking at like a decade's worth of data on this, and they found there was basically a 0.1% prevent detection of crime with stop and search. So it had basically no effect at all on crime, which is the driver for bringing it in the first place. So. And also the other thing here I think which is important is that it's in the context of serious violence. Now, the risk profile of both the perpetrators and the victims, although it's a difficult area to get into because it's a very confused area, this sort of victim and perpetrator narrative is unhelpful. But it does disproportionately affect, according to the statistics, the sections of the black community. But what that means is, it's a controversial. I mean, it's a difficult point to get across. But because it's maybe slightly more likely that community might be more prone to the effects of violence. The response doesn't go in a linear progression. So say it's like 2% more likely doesn't mean you get 2% more policing. It's I don't know what the mathematical phrase is, but that little tiny bit results in an enormous overuse. So you see it, for example, something that I'm very familiar with Taser. It's closely related to stop and search, but because Taser is a weapon that's brought in specifically to deal with violence. So because it's known that the risk profile in certain areas, especially amongst the black community, is that there are slightly more higher chance of there being violence involved, only slightly more, but it's there. What it means is that every time the police go out to that kind of area, they've got a taser with them. So it means that they massively use taser way more than they should against that population, 8 or 9 times. It's staggering. And so that's why I think that any attempt to, and this is what the combination of the serious violence duty, which creates this new kind of data sharing panacea amongst police and local authorities in part 2 of the bill, and the way that's going to relate to section 10, which is these new powers to these new orders, these like ASBOs for violence, and the joint enterprise aspect that goes along with it, that what that's going to do is it's going to create these kind of markers and these red flags on people where there is very questionable evidence. Because another thing the bill does is reduce the threshold of evidence with which you can put these things on people, and it's gonna. We've already seen it in our looking at other tools, especially around gangs profiling in London, where what you essentially do is create red flags that get put on individuals that follow them through the whole local community. So it affects their access to jobs, to housing, not just their interactions with police, but so they are stopped and searched routinely because of it. But they're also flagged as violent people or problematic people or gang members, and therefore the schools don't want them, and they can't get a job, or housing associations want their families removed. The real life harmful consequences for having these things placed on people.
I mean, sorry, it's very much Oliver's area. I completely share all of his concerns, because we've been having some conversations with the Criminal Justice Alliance, who I'm sure Oliver is familiar with. But I think, the statistics are obviously staggering, isn't it? I think it's something like 18 times more likely. But the more sort of damaging impact, and we get contacted a lot on this through our through our publicly available email to where people ask for help. But it's for me, the bigger concern is the erosion of trust, because that's the sort of you've got the real practical policing issue, and that is, is focused. The black community bears the worst brunt of it, but then other ethnic minority communities then share that lack of trust and once that trust gets eroded, that leads to all sorts of problems. So yeah, I mean, it's a significant concern, and I mean, it's only going to get worse under proposals.
Brilliant. Thank you both so much for answering the questions and also just attending this session. Both of you addressed like the issue of PCSC so well and so clearly. But I think as for that, we do have another Law Society event scheduled like right now. But yeah, thank you both for speaking to us. It's been really informative. We really appreciate it. So yeah, all right.
That's a pleasure. Thank you.
Thank you. Anytime.
All right.
Thank you.